Hi and welcome to this latest immigration law update video. On the 14th of May 2020, the government laid before Parliament a new Statement of Changes in the Immigration Rules, CP 232, and the link's in the description below. And despite us being in the midst of the coronavirus pandemic and lockdown, the government has still found the time to make some changes to various routes. And one of the routes they've made changes to is the representatives of overseas businesses, Rule 144 of the immigration rules, what we know as sole reps. Now, over the last year or so, we've seen a huge increase in the number of applications under this route. That's because the entrepreneur route was closed by the government. And Appendix W, which deals with innovators and startups, is hugely problematic because of the problem getting an endorsement from an endorsing body. So there's been an increase in sole rep applications in the last year or so. And what we've seen is the government now tightening up. And the big change in this statement of changes is the introduction of a subjective genuineness test. Now, of course, an application has to be genuine, but now this has been explicitly put in the rules. And practitioners will remember that a lot of the entrepreneur applications were refused on the basis it was not accepted they were genuine. So let's have a look at the changes, and I'm just having a look at the statement of changes now. So firstly, at the start of paragraph 144, the words genuinely are added at the start. So it's there at the start. In relation to Roman 1 of 144, there's a clarification that the business is an overseas business and will continue to have its headquarters overseas. So there still must be that headquarters overseas. Then in Roman 2 little a, there's a change because at the end of that rule, it talks about being a senior employee who's coming to set up a branch or subsidiary, and it says, and is not being established solely for the purpose of facilitating the entry and stay of the applicant. So I think we'll see a lot of refusals now where entry clearance officers saying, we just think this is not genuine. We think it's just for the purpose of facilitating the entry and stay of an applicant. And again, in Roman 3a, it says this will be the sole representative of that overseas business present in the United Kingdom under the terms of this paragraph. And you listen to this, with the skills, experience and knowledge of the business necessary to undertake that role and the full authority to negotiate and take operational decisions on behalf of that business. So again, you can see what we're going to see in refusals from entry clearance officers where you don't have the skills, experience and knowledge in order to negotiate and take operational decisions on behalf of that business. Again, there's a clarification. These are a series, it says in the explanatory memorandum, it's a series of clarifications and amendments. So in Roman 3b, there's a clarification that you must not intend to engage in any other business of your own or any other business interest. Now, we know also from Roman 3c that you mustn't be the majority shareholder in that business, but that's now been widened and clarified. It now says does not have a majority stake in or otherwise own or control that overseas business, whether that ownership or control is by means of a shareholding, partnership agreement, sole proprietorship, or any other arrangement. So there's no getting around it now. If you're the majority owner, you're going to get refused. Again, in terms of the evidence that's needed in Roman 3d, there's a clarification in the type of letter that's needed from the employer and the details that needs to contain, including confirming that you've got the full powers to negotiate and take operational decisions. In terms of extension applications, 147 is amended to confirm that the business you set up has to be set up in the United Kingdom. And then an interesting development is the change to dependents under paragraph 194, Roman 9 of the immigration rules, that the dependent partner can't be the majority owner. So in a husband and wife situation, husband could enter as a sole rep, and sometimes they bring their partner as dependent, and in fact they've reconfigured the business so the partner is the majority owner. Well, that no longer can be the case, and that's been amended. So we're seeing a tightening up. this introduction of explicit subjective genuineness test, and this tightening up of majority shareholders and majority owner criterion. Now remember, if you apply before this comes into force, it comes into force on the 4th of June 2020, you're under the old rules. I know it's difficult to make an application at the moment, but before 4th of June, you're under the old rules. After 4th of June onwards, it's under these new provisions, and you'll need to address specifically this genuineness test, which is now incorporated within the rules. So do check out those changes. I've put the link in the description below.